Hey, my trendies, trendsetters, and my trendy tribe. How are y'all doing? Mic check, 1 2 1 2. Let me know if you can hear me. I got over a coughing fit right before I came. Well, 10 minutes before I came on. Liquid went down the wrong pipe, and now I'm sitting up here trying to recover and not sound silly. I see them vibrating. That's a good sign. Okay. For anyone new to the channel, or if you just aren't aware, I do greet people in the lives for a little bit. I will timestamp when I actually get on topic if you want to come back for the replay, but I go live so I can interact. Excuse me, sorry. Can y'all hear me? I think y'all can hear me. I see my circle vibrating. Okay, if I bleep out or blip out from StreamYard, I will be back. So let's start with some greetings. Okay, Patricia Dyer, how are you doing? First in the building. How are you? Good evening. Hey, Veronica Monroe. Hey, Gloria Strickland. Hi, Jesse Bradley Lewis. Happy Friday. Professor Demita Anita Baker Joe. Happy Friday to you. Hi, Cynthia Scott. Hey, Ann Green. Hi, Deborah Johnson. Hey, Leslie Barber. Hey, Peace, Love, Prayers. She said, I'm hooked. Couldn't miss this. Thank you for being here, Peace, Love, Prayers. Hey, Pen2 Ross in the bushes. I got you. Did I say hey to Veronica? Yes. Okay. Hey, Debbie Gwen. Hi, Annette GL. Hey, Tyler and Tymon G Mom. Patricia Ellis Robinson. Hey, Kashori B. Hey, Leah's Grandma +1. Hey, Braylon Lee, content creator. No problem, Braylon. Okay. Hey, Ruthie Lewis. Let's see here. Hey, Flory Hook. How are you doing? Let's see. Stacy Belton, good evening to you. I'm going down. Good evening, Hottie Stuff. Hey, who said that? How are you doing? Linda Gamble, YouTube MVP and in the Mod Squad. How are you doing, Linda? Let's see. I see. Hold on. I see my sis, Mary Kelly. Hey, sis. And I see LS. Hey, LS. How are you? Hey, Lisa Girl 1100, Essence Tender 1. Hey, Daphne Brown, MC Geechee, I see you. Hey, Sheila Massey, court is in session. Hi, BG. Hey, Purple Unicorn. Hey, Joe, how you been? Talking Out Loud, also a content creator and one of my Leo sisters. How are you, Talking Out Loud? Hey, Esther Jones from The Shy. Jennifer Turner, how you doing? Let me see. Hey, Janet Jenkins. Hey, Lies More Lies. Hi, Nisha. Hey, Jamie. Hi, Terry T. Baby Davis. Hi, Deborah Jones. Finally catching a live. Yes. Hey, Diane Sanders. Also finally catching a live. Yes. Hey, Tamara Allen. Oh, thank you. And yes, I'm glad you brought that up. I always link the creator of the song in my description box if y'all want to go check out their channel. The name of this song is generically titled. It's just called Emotional Love Song. You got to go through the catalog and try to find it because I don't know. But he creates a lot of music and I don't know who he's getting to sing the songs, but I got the channel link for you. So hey, my big sis Shan. Hey, Claudia Beard. We ready for the zen of it all. Yes, Claudia. Did I say hey to the real VB? I'm gonna say hey just to make sure. Let's see. Hey, let's be clear in the bushes. Okay. I hope you can listen to. I hope it's slow for you today. Hey, Queen Sidnor, Rhonda F. Good evening. Francois, just in time. Yes. Hey, Soul Star Music Lover. Happy Friday. Hi, Sheila Jackson. Let me see. Terry Babe 89. How are you? Cut and paste Tisha's in the building. Hey. Hi, just listening. How are you doing? Shan, my legal eagle, is here and part of the mod squad. Let me see. Hey, Titi. Astute Queen B Thoughts is in the building as well. Hi, Tracy Williams. Hey, D Good. Let me see. I'll do a few more. Hey, Steph M. I'm good. How are you doing? Susie Q for real is here. Janetta Boyd is here. Let me see. Cynthia Bowman, how are you? Okay. I'm going down just a little bit more. Hey, Sylvia P. Joy S. Pick is here as well. I just saw you. Okay. Diane Davis, blessings to you as well. Hey, TCB. Queen 3K is here. Hey. Hey, so what? Hey, Harolyn Baker. Okay, I'll stop there. Okay. Hey, Brenda Wallace. I'll stop there. That's as far as I can see down so far. So I'll stop there. But thank you. And Miss Reese is a new Trendy Tribe member. Oh, snap. I see a super chat. Peace, love, and prayers. Thank you for the super chats. Trending prayers up that you will receive gifts of appreciation for your very hard work. Please support this channel with likes, subscribers. Yes, thank you. Thank you, peace, love, prayers. I receive it. Yes. Okay. Got a couple things on the docket and we will get started. Again, I will timestamp it, but some of y'all, you know my flow. Okay. So Sketchy Saturday, last Saturday, Sketchy Saturday was Multiple Sclerosis Awareness. And for the Trendy Tribe members, either on Patreon or the YouTube membership side, you can download my Sketchy Saturday art for free. I post a link a couple days, usually after we have the Sketchy Saturday. And let's see here. And we have 5 Minutes with Fit was today's Mondays and Fridays. I hope y'all join us. Fit brought out that step, the step for It's Chrissy Time. It was really good. It was too cute. Really appreciate it. We also talked about the Purdue Sackler lawsuit today. We went over that lawsuit of the state of New York versus Purdue Sackler, Johnson & Johnson, a few names. So it was very informative, y'all. So if you get a chance, please go back and watch it. And I just think it'll tie in well. So if you like reviewing lawsuits, I think you would enjoy some of the listening and seeing some of the predatory practices that they use. Some you know, some you might not know. So okay. Also, since I haven't seen anything new after this Zen Garden document, I'm going to go over. We are reviewing how the couple finally got Destiny out of Madani. So if you're interested in that, we started. We only have part 1 so far, so we're reviewing that over here too. If you want to see the, how it all happened in chronological order, based on the legal documents, we will be over here doing that. Let's see. Okay. So anything I go over, first of all, it was public record. I'm using it for critiquing, commentary, research, and reporting. And so, as you know, we are here for the part 6 of it all, where Scholt calls Zen Gardens opposition to their request for summary judgment. What do they call it? Melodramatic, or they use the word melodrama. That's why I put that in the title, because I felt like that was I was like, all right, melodrama. So that's why it's titled that way. Let me see. And do I have anything else? Oh, tomorrow is normally Sketchy Saturday because tomorrow's Saturday. If I have an unexpected like mini trip coming up, I'll have to play it by ear. But if everything goes to plan, we have Sketchy Saturday tomorrow at 5 p.m. Eastern Standard Time. And then we go and watch Love and Marriage Huntsville live, the newest episode over. Well, I do it through a StreamYard link for the Trendy Tribe members. So if y'all like to join us, that's normally what we do. I'm playing tomorrow by ear though, just in case. Okay. Let me see what's going on. All right. I think we're good. Oh, I know. Thank you, MC Geechee, for the Cash App as well. Thank you so much. And Carolyn, hold on. I don't want to say your name in case you put it. Okay, I'll just say thank you. Oh, I'll just say thank you. Okay, thank you so much for the Cash App. Let me stop before I start saying names on accident. Thank you so much for the Cash App. I appreciate it. So before we get started, we'll pop the trunk one time and I'll pop the trunk again at the end. But thank you so much for the super chats and the Cash Apps. Where's my man in the trunk? Okay,
here. All right, we going. What a money reside. What a money reside. What a money reside. What a money reside.
Thank you so much. Oh, I better not accidentally hit end stream. That would be bad. Okay, my Leo sis, Live, Laugh, Love, aka Lady T-Bug, is in the building. She is a content creator and part of the Mod Squad as well. I see you, Live, Laugh, Love. All right, I'm bringing up my documents now. Let's see what we have. All right, let me make that a little bigger. Sorry for it being off. Let me see. Let me scoot that over. Does that help or hurt? That hurts. Hold on. Let me see. Can I bring up one more thing? No. Okay, that's where it's going to be. Okay, at least we can see all the words, though. We'll be fine. All right, y'all. So what we're looking at is, I'm just going to take you through a small refresher. We're on part 6, so you already know we've been through a lot. But basically, there was the deposition of Mr. Vishal Shah from Zen Gardens. Then there was the deposition of Marsau, the famous I Do Not Recall saga. Then we have where they talked about where Scholt requested a request for summary judgment where they wanted Zen Gardens counter complaint to basically, I believe, be dismissed, plus they wanted their contractor's fee. And then Zen Gardens responded to that, saying that Scholt cost them millions. They didn't, basically there's some things in the contract that protects them. And now Scholt has come back to say, no, you're just trying to conflate things, blah, blah, blah. So that's where we're at, where Scholt has answered Zen Gardens like, no, we still want our summary judgment. And we'll see where it goes after that. But that's where we're at right now. Okay, and all the parts, all 1 through 5 are linked in the description box as well, if you ever want to play catch up. Okay, so this is from the Scholt attorney, which Scholt is, y'all know that's Marsau, basically. It's mostly Marsau. Okay, let me get my banner up. Hold on. All right. Hey, Tammy Van. Hey, Dr. Minnie. I see you. Hey, Cricket22. All right, so it says the counterclaim defendant, Scholt Industries, submits this reply in further support of its motion for partial summary judgment. Stated simply, Zen's brief in opposition to Scolt's motion for partial summary judgment fails to rebut the valid arguments presented in Scolt's own brief in support of same. Zen's failure is amply evidenced by 1, Zen's demand for some $1 million from Scholt, despite Zen's not meeting even the basic contractual conditions for recovery of same. 2, Zen's continued allegations of fraud, despite Zen's utter inability to prove the element of reliance. And the element of reliance is very important for fraud because this is from I went to one of the legal websites to find out, but so reliance is a legal concept defining the dependence by one person on another person's or entity's statements or actions, particularly where the person acts upon such dependence. The person on whom the person relied may be liable for damages if such reliance was reasonable and resulted in detriment to the relying person, in a doctrine known as promissory estoppel. So Zen Gardens is saying we reasonably relied on on Scholt, that they represented themselves as having so many years of experience and all these things, or bringing on experienced people. Promissory estoppel, within contract law, promissory estoppel refers to the doctrine that a party may recover on the basis of a promise made when the party's reliance on that promise was reasonable and the party attempting to recover detrimentally relied on the promise. And number 3, they're saying that Zen's general failures to respond in any meaningful way to Scholt's arguments for summary judgment. So they're saying the whole thing that we reviewed in part 5, there was nothing meaningful that Zen brought forward. That's what they're trying to say. Okay, so this is their reply to Zen's presented facts. So they're saying that Zen improperly disputes all these paragraphs from Scholt's undisputed material facts by A, editorializing to avoid confronting the facts, and B, ignoring the testimony and evidence cited to support such facts, arguing that Vishal Shah didn't actually mean what he testified to, and or tendering wholly irrelevant argument. So they're saying when Zen presented their facts, they editorialized the facts instead of just presenting them as they were. So basically they're saying that Zen Gardens injected their personal interpretations or opinions into an otherwise factual account. So they're saying that they editorialized the contract, the depositions, and the proposal, I believe. So yeah. Zen also, according to Scholt, Zen also improperly responded to paragraphs 20 through 21 and 28 through 29 of Scholt's undisputed material facts, with statements from Shah himself, sometimes with further editorializing, mere conclusions, and unsupported self-serving statements by a party opposing summary judgment are insufficient to avoid summary judgment. So we are going to look at paragraphs 20 and 21 and 28 and 29 to refresh our memories, to see what they're saying Zen Gardens did not respond properly to. So let's go on down memory lane. So paragraph 20, it says, while Zen eventually, this is from Zen Gardens, while Zen eventually met some of Scholt's subcontractors, Zen did not present Scholt with any of his own. Further, it was Scholt's responsibility to furnish qualified subcontractors under the contract terms. Zen also says that Zen did not work with Scholt to develop its entire bid. Rather, Zen helped Scholt bring down certain costs. Examples, costs associated with certain subcontracting trades with owner procured items. Hold on, y'all. Mr. Trinity forgot I'm live. Hold on. I bust out. He just heard me. I'm so sorry. I'm so sorry. Okay. And then let me see. Hey, T Talk with your girl, content creator out here. Hey, Chronicles of Kim K and Reem Bass. I see y'all. Okay. So let's see here. Then we have this, say paragraphs 28 and 29. Let me double check. So we're not, 28 and 29. Okay. So Zen said that Mr. Shah testified that he did not have any direct contract with the subcontractors before Zen awarded Scholt the contract for the Zen Gardens apartment project. Just to refresh your memory, Scholt is trying to put the responsibility either a 50-50 or all on Zen, from my own interpretation, to say that they had just as much of an equal hand, if not overbearing hand, with the subcontractors. Zen disputes that, and also Zen is saying that Scholt was, in accordance with its representations and the parties' agreement, supposed to hire skilled persons to work on the project. Only when Scholt failed to meet this obligation did Zen hire entities and personnel to work on the project. For instance, Zen hired M&C in November 2020, only to fill the project manager and superintendent roles Scholt left vacant. The other entities Zen hired were there simply to cure or rectify the poor workmanship of Scholt's hired personnel, be they vendors or subcontractors. If y'all remember the pavement issue and the clubhouse issue that had to be torn down and rebuilt. Let me see. I'm just trying to make sure. Okay. All right. So we're going back to Scholt's reply on why they think the summary judgment should move forward, because they want their money and they want Zen to not have a dog in the fight, basically. And then it says, finally, Zen's response to paragraph 37 is an issue of contractual interpretation and is therefore inappropriate. So Hi, Deb. Yes, we're going to go over that contract again in pieces. But yes, ma'am, Deb, the contract says Scholt won't get paid if they don't finish the project. Also, they had deadlines they missed. Now, I have to qualify that because Scholt, had they presented what they were supposed to present, would have at least gotten reimbursed for some expenses. Scholt would not get that contractor's fee because they did not meet their milestones. So that's what Zen is saying, we don't owe you because you failed to meet any of the milestones. So that's where they missed and where they cannot get their money back. It is on Scholt on why they're not getting the other pieces of money back, which we shall review. Okay, let's see here. Paragraph 37. So Zen is saying, oh, okay, never mind. They didn't say what it was. Okay, so now we're into Scholt's reply to the additional undisputed material facts. Scholt does not dispute the allegations in paragraph 2, 4, 6, 8, 9, and 15. Then they go on to present their parts, and it says Zen asserts that Marsau Scott refused to answer more than 24 questions during his deposition, rendering the same admitted. However, Zen fails to specify the admissions Scott purportedly made in a manner pursuant to Appendix 2. As such, a response to paragraph 1 is unwarranted. So I'm going to say that, first of all, I think the first part is true. And I don't even know if they're disputing the first part, that Marsau literally refused to answer more than 24 questions. I don't think that part's in question on either side. But what Scholt is saying is that he also didn't answer the questions to where Zen Gardens could draw their conclusions for the rest of it because he never answered those questions. Number 3, Scholt is saying it's undisputed only insofar as Marsau Scott is from Pontiac, Michigan. Also undisputed only. They say they don't dispute paragraph 5 insofar as Scott and his brothers started M&M pools. So they're saying that part is fact, but they do dispute to the extent that Zen seeks to inappropriately impute Scott's career experience to that of Scholt. And impute means represent something, especially something undesirable, as being done, caused, or possessed by someone. Then they go to paragraph 10. They dispute paragraph 10. It says Zen's site does not contain this sentence. It is an amalgam of a heading in one document and a sentence in another version of that document. And I'll tell y'all what they're talking about. Okay, so basically, let's go to Zen's paragraph 10 so y'all can see what Zen wrote. And I'll tell you where I feel that they got it from. And then the lawyer's going to have to argue about should they have just, put those two things together and said that. So I'm trying to get to the right number 10. Hold on. Paragraph 10. Here we come. Okay. So in paragraph 10 on Zen's side, Zen said in the bid, Scholt represented it had a track record of specializing in hotels and multiple family building construction. And they say see Exhibit 5 bids, Scholt's bid proposal. So we're going to go to Exhibit 5. Let me make sure I go to the right page. Let's see. Here we go. Okay. So we're going to go to 91 first. So this is where I think they put the two together. This is just my opinion, though. This isn't, take me with a grain of salt, please. Okay. Okay. So the first part where I feel that they connected these statements, and again, what Zen is saying that Scholt said is Scholt represented it had a track record of specializing in hotels and multifamily building construction. Okay. So in this first part, let me see. This is where I think they started building it from. Sorry. Scholt has assembled an excellent team with over 25 years of experience in construction management and general contracting specific to multifamily building construction. Our company has the necessary knowledge and experience to undertake a project of this size on behalf of Zen Gardens apartment project partners. Our project delivery goal is on time and within budget. That's part of it. And then I feel like the other part came from, let me see. Okay, it was a very small sentence. But let me show y'all where I saw the other part for the track record phrase. Okay, right here, a track record of success. So Scholt is saying they put those two things together. For citation wise, that's yeah, okay, you have to cite exactly as you see, but reasoning wise, I'm like, they did present themselves like they could do this and they were gonna have the people. Okay. Now let's go on back. So then it says they dispute paragraph 11 to the extent that Zen implies Scholt made the misrepresentation claimed in paragraph 10, which we just went over. They don't dispute that Scholt had undertaken one hotel project at the time. Then on paragraph 12, Scholt says they undispute the part that Scholt stated at the time of proposal. Those individuals were slated for use at the project in the parameters listed, with the exception of Michael Scott, who was slated to be senior project manager. They do dispute that there was misrepresentation made and that Mr. Allen's and Mr. Carroll's ultimate absence at the project, which is who Scholt listed in their proposal, and Michael Scott's remote position caused lack of directions and or tardy materials. So they're saying that the absence of all the people they presented in their proposal did not cause lack of direction and or tardy materials. That's what Scholt is saying. They're saying that Scolt's bid package was submitted on September 27th, 2019. It says, and these individuals are listed for a project that was set to begin on October 27th, 2019. Please keep that in mind because we're going to go to the contract and look at a clause on when the contract starts, because this is where, oh, this is such a layman's opinion. I cannot be held to this because it's just an opinion. I think Scolt's attorney is just like, let me get my billable hours, because literally as they're saying that they're misusing the interpretation of the contract, I'm going to show y'all in the contract where it, to me, clearly states when the project was supposed to start. And that's what Marsau signed and agreed to. But that's just me. And it says, however, the notice to proceed did not issue until March 2nd, 2020. So Marsau and his attorney are holding to the fact that those people would have been there to start in October 2019, but they didn't get the notice to proceed until March 2nd, 2020. Okay. And then they try to do a little jab. They said likely due to funding issues, which continued well past the original commencement date. So they're trying to say basically because Zen Gardens couldn't secure the funding, which if y'all recall in the previous parts, Marsau had to bring them Eva Bank to get financed, right? But now they're trying to create that jab that, oh, Zen Gardens couldn't get funding and they delayed us, right? I see you, live, laugh, love. Okay, so we have to go look at Article 4 of the contract. So let's go find that. Let's see here. Which one is this one? Okay, we're looking for Article 4. Okay, Article 4. This is about when the contract starts. Just read along with me. Article 4, date of commencement and substantial completion. Please see where the X is placed in the box. And it's not handwritten in. It's in there typed. And it says a date set forth in a notice to proceed issued by the owner. A written notice to proceed will be delivered by owner no later than 48 hours following the owner's closing on a construction loan to fund the work. The owner's loan closing is anticipated to occur sometime the week of February 24th, 2020. This agreement shall not be effective until the owner delivers a written notice to proceed to the contractor, and such notice to proceed may not be issued until A, the owner is the record owner of the property where the project is to be completed, as evidenced by providing the contractor a copy of a recorded deed vesting title for such property in owner, and B, the owner has closed on the construction loan mentioned above with Eva Bank for a projected amount of $10,683,147.57. The actual amount may vary by as much as $10,000 to reflect the actual amount of the loan, and provided written evidence of such closing to the contractor. If a date of commencement of the work is not selected, then the date of the commencement shall be the date of this agreement. Y'all, it says the agreement, this starts when they get the notice to proceed. You really can't misunderstand that. I don't have to be in construction to know that and you signed it saying the job starts when you receive the notice to proceed. And then on top of that, it was estimated for February when he signed it. So in this paragraph, it's anticipated to occur February 24th of 2020. They ended up getting it in March of 2020. So you didn't even have to wait that long from the time you signed it. So miss me, but that's why I don't know. I'm like, in my humble opinion, is the attorney just billing their hours and they just moving along? Because that doesn't make sense to me as soon as you see the contract. Okay, let me see what we have to go to next. Okay, we're going back to Scholt's brief. And so paragraph 13 says they dispute that Scholt represented it had in-house engineers. They dispute that Scholt represented it performed general contracting work on those projects. And I'll show you, because Marsau in his deposition either refused to answer or did say, I do not recall a lot. So I don't even know if he did ever admit to what he did on those projects that he claimed gave him experience. But we're going to go back to their proposal and look at the times that Marsau's name was mentioned, just to see. And I'm not saying this proves that he did anything. I'm just want to show you how he presented it on his proposal, because we got to keep our memories fresh. So these top two lines up here is Marsau's projects. Infinity Properties LLC, which used to be Infinity Pools. I think it was M&M Pools to Infinity Pools to Infinity Properties, which now, of course, Tisha's the majority owner, I believe, from his deposition. And all it says is his title is under project manager, just so you know. And then the other one is through MJS LLC, which I believe is Marsau, what's his middle name? Javon Scott or something like that. That's his other project. And again, he's under project manager. So I won't even say semantics, but technically they didn't say, I don't remember him admitting that he did general contracting. I remember he wouldn't admit what he did once he was asked in the deposition. So there you go on that one. Okay. Now we're in paragraph 16. I'm going to say hi real fast. Hey, Color Be Entertained, content creator. We got Mildred Conversations and Cocktails, also a content creator. Designs and Decor, also a content creator. Okay, Robin Wilson said, I understand the cliche, never let them see you sweat, but the Scots walk around those Huntsville streets like they are unbothered. Robin, the more I read, the more I'm like, what do y'all do? Because I don't get how you can act like there's nothing going on. Let's be clear, says she's subscribed to everyone highlighted. Okay, so paragraph 16, it says, Scholt is without sufficient information to determine the extent, if any, of Zen's reliance. As such, Scholt disputes this allegation. So Zen relied on each of Scholt's, the paragraph that they're disputing is Zen relied on each of Scholt's misrepresentations in his proposal when it awarded Scholt the contract. So they're saying that Scholt doesn't have sufficient information on how Zen relied on them to be able to award the contract to them. But to me, your proposal is already a reliance that someone has on you. And then if you looked up the people they listed, like Michael Scott, what were their names? Hold on, let's see who else they put in here. We got Uncle Michael Scott. We have Alan Legier. I'm saying Legier. I don't know if it's Lager. I'll say Legier. Alan Legier with all of his experience. So yeah, I don't understand, but that's not for me to prove or disprove. We're just gonna be here to watch. Okay. Then paragraph 17 says Zen accurately quotes portions of the contract. Undisputed, Scholt stated at time of the proposal, those individuals were slated for use at the project, and they ultimately either did not work or briefly worked remotely at the project, otherwise disputed. Paragraph 18, they dispute as to implication that all payment was conditioned upon completion of the milestones by a certain date, and that failure to meet said date foreclosed payment. They also dispute that contract milestones, especially the third substantial milestone, were never met, and that Scholt is responsible for the clubhouse's condition. The clubhouse, I believe, was the one where it was built 14 inches too short. It had to be torn down and rebuilt, just so y'all know. And then the fact that they're disputing that the contract milestones were never met, especially the third. Well, if you play semantics, the milestones were eventually completed They were not completed at the time that they could have got the incentive, and it seems that they were completed by people that were brought in and not so much Scholt anymore. That's the question of the hour, Veronica. I don't know why would they even submit a bid exactly. And then let's talk about this payment, because they're saying that they deserve payment, right? So let's go back to the contract. Let's see where we at. Article 11. Let's go back. Where is my contract? Let's see here. And again, this is only my layman interpretation, and I understand it. So this is for entertainment purposes only. Okay. Accounting records. So Article 11 says the contractor shall keep full and detailed records and accounts related to the cost of the work and exercise such controls as may be necessary for proper financial management under this contract and to substantiate all costs incurred. The accounting and control systems shall be satisfactory to the owner. The owner is Zen Gardens. The owner and the owner's auditors shall, during regular business hours and upon reasonable notice, be afforded access to and shall be permitted to audit and copy the contractor's records and accounts, including complete documentation supporting accounting entries, books, job costs, reports, correspondence, instructions, drawings, receipts, subcontracts, subcontractors' proposals, subcontractors' invoices, purchase orders, vouchers, memoranda, and other data relating to this contract. The contractor shall preserve these records for a period of 3 years after final payment or for such longer period as may be required by law. Just lazy, Miss Lucy, right? Yes, entertainment purposes only. Okay, so the fact that hold on, there's another part, but maybe it's coming later. We got to talk about that closing book again. It might be coming up later. My contract girl perked up. That also talks about that closing book. I think we should get there. I made myself a note, so hopefully it's worked in here organically. But yeah, you have to provide something to get your money. And what in the deposition Mr. Shaw said was he does feel that they do owe Scholt something or some money or something like that, but Scholt never turned in their closing books, other documents, and they asked for 2 audits, and the documentation that was given to them when they asked for those 2 separate audits was so unintelligible. Like they just didn't even know what they were looking at. And this is professional people that do audits. They were like, they did not know what they were seeing, what Scholt turned into them. They couldn't make heads or tails of it. I'm paraphrasing. Janetta, I know. Oh, I don't know tomorrow. It's possible. I've heard. Okay. See where all that fast talking got them? Yep. Okay. Let's see. Okay. Then they're disputing the fact that Marsau conceded that Scholt failed to meet the second contract milestone in accordance with the contract terms. I think he did refuse to answer. So technically they're right. He didn't concede. He just wouldn't answer the question. That's where he just kind of he closed that mouth up real good. Hey, Juan Davis. Exactly, which is very reasonable. Very reasonable, Live, Laugh, Love. They want to reconcile the accounts and costs. Okay. Then it says, Scholt is without sufficient information to determine the extent, if at all, that Zen was faced with, quote, tremendous cost. As such, Scholt denies the same. So they're saying that they don't have enough information to see that they cost Zen all that money. Then paragraph 19, Scholt disputed Zen's reasons for hiring the several persons and entities, including Martin and Kobe. Martin and Kobe were a key player that were brought in when they realized that, like, I think Uncle Mike wasn't gonna be there like that. Was Basement Billy? It was Basement Billy. It was somebody else that was supposed to be there. They weren't there. Alan Legier, he wasn't there. So Zen's assertion as to the context of Martin and Kobe's hiring is untrue, according to Scholt. And they dispute all other assertions. Then Scholt also disputes as to Zen's implication. Scholt breached the contract by not seeking an extension for the substantial completion deadline. Well, they didn't. Scholt admitted they never asked officially for an extension. I don't even know if they admitted they asked unofficially for a deadline extension. A whole lot of words and saying nothing, Dr. Minnie. Right, Mary, that's the first he shut his mouth. They wordplay too much. They do color me entertained. I agree. Okay. So then let's go to Zen, or Scolt's arguments are that Zen is not entitled to liquidated damages of $1 million because Zen cannot provide any proof Scholt did not commence cure of any alleged defaults, and in fact, Scholt remained on the project performing in a way that kept it on the project. Okay, let me see where I broke it down, but we got to talk about what cure actually means. Cure is very specific, especially in construction and some things. You can't just, because you were still present and clocked in, that doesn't mean you were curing the issue. I need to make that very clear. Oh, look, and then I wrote what one of y'all wrote. I said, in my opinion, this is a lazy reply. This is okay. So Scholt is saying Zen misleadingly represents entitlement to some $1 million from Scholt. Then Scholt says, in fairness, Scholt received notices of alleged defaults in February 17th, 2021 and March 3rd, 2021. Yeah, in all fairness, in certified mail, you sure did. They have to admit that because there's already proof, which we're going to go over one of those letters. However, basically, it is undisputed Scholt remained on site and continued working to cure any alleged defaults. Again, I feel like they're using that term real loosely. It says, by the express terms of the contractual provision cited by Zen, Zen is only entitled to the claimed damages if Scholt fails to commence the cure of any alleged default. Such did not occur. So they're saying that I guess they're saying that Scholt did not fail to cure the default. Okay, let's go to the letter, but let me see what my note says. Oh, okay. My first note says, I feel like Scholt is glossing over the default, the notices of default in the first place. Now, let's see, what is this one? Okay, we're going to look at the letter. I made a note and said Scholt received explicit instructions on the definition of the cure for default. Staying on site, in my opinion, would not be a cure for default. That's, that's like step 1.A, but you didn't do anything yet just because you're there. Okay, so then first you know what? Hold on, let me see. Did I put it? I don't know where I put it. Let me see. Because I'm trying not to get ahead of myself. Okay, we're going to get there. So we're going to go to the notice of default first. I'm making sure I don't get ahead of where I wanted to show y'all. I'm trying to keep it in order. All right, let's look at one of the notices of default. This is the February 17th, 2021. And y'all that were here for part 5 saw it, but we have to look at the cure instructions, okay? Notice of default sent to Marsau the first time. Let's see. Let's go down. Where's it at? All right, it says, please be advised that if satisfactory arrangements are not made to resolve these matters within 15 days from the date this letter is sent, my client will be forced to utilize any remedy available under the laws of Alabama or otherwise to protect its interests. However, while my client reserves all rights under the contract, Zen Gardens LLC is willing to forbear initiating default remedies if Scholt executes a forbearance agreement in a form approved by Zen Gardens LLC containing the following provisions. So it says, number 1, and this is all inclusive. You can't pick and choose. It's not a buffet, okay? Hey, Doreen, how are you? Okay. Let's see. Heroin, I did see that. I don't know for sure the reason, but the money's funny and the amounts look real similar, but I did see that. I saw that what it was reduced to. I can't remember if I actually saw the original amount. Let me tell my truth. I did see it got reduced to that though. Okay. All right. So number 1, Scholt has to comply with the construction schedule produced by Martin and Colby as attached here too. Number 2, and this is an and, not an or, and they have to execute a deed in lieu of foreclosure in favor of my client's nominee to be held in escrow, only to be released to my client should Scholt not reach substantial completion in accordance with the Martin and Colby schedule. And they have to fully cooperate with my client's audit of Scholt's accounting records related to work And should the stated cost be 5% or more than actual cost, Scholt shall beat the cost of the audit in addition to reimbursement to my client for overcharges, and agree to a waiver of the contractor's fee of $350,000 for the stated defaults, in addition to an acknowledgement of my client's rights as reserved in the amendment referenced above, and list my client and the required parties as additional insureds under the applicable insurance policies, and execute an unconditional lien waiver in a form approved by Zen Gardens LLC. It says, I urge you to take advantage of this opportunity that my client is extending to you to remedy this default. Default is used all up and through this letter. To discuss the details of Scholt's default and the proposed forbearance, please contact my office. One more thing I want to point out is that they had to decline, no, we will not cancel the previous default, when they had to send it again to them later. It says, furthermore, this is in March. It says, furthermore, in my response to your letter dated March 2nd, please know that my client refuses Scholt's request to withdraw the previous notice of default concerning your client's failure to substantially complete phases 1 and 2 within the contractually agreed timeframes. Hey, Simone. Hey, Lisa. Okay, so there's the notice of default. Let's talk about, okay, well, let me stay in order. I get excited. Let me just go in order. Let's see. So then it says, Scholt is saying this again. We're back to what Scholt is saying. Zen then errantly argues it was forced to hire entities such as M&C to make up for Scholt's alleged deficiencies. Yet, Zen hired M&C in October or November 2020 when Scholt had not yet missed the third contract milestone. Here's my thing. This is personally me. I know I'm not them, but if I were Zen, I also would not wait for you to miss the third milestone if you've already missed the first and second. I wouldn't wait for you to miss the second milestone. Honestly, if you're getting close to missing the first, I'm probably already bringing in my people. I'm sorry. If that's legal, that's what I'd be doing. So yeah, but the argument, I guess they have to try to argue that. So then it says, worse, Shaw seemingly intended to use M&C as early as 2018. They'll have to explain that. I don't know if they were just pre-vetting people because they knew that it was such complex stuff that they were like, let me get my ducks in a row, but they'll have to explain that. Zen Gardens will. I don't know. Then it says, notably, Shaw cannot answer whether Zen gave Scholt written notice of default when Zen actually hired M&C, and no such notice has been produced. But here's the thing. It's so funny that they say Mr. Shaw, who, you know, is with Zen Gardens, could not directly say when he gave the letter, had M&C been hired yet. It doesn't, to me, layman, it does not matter because the notice of default was still given formally via certified mail. You got email, they sent it to his attorney, all these things. So I don't understand how that, I don't understand how that matters, but it may help their argument. But you were given notices of default, and Martin and Kobe were mentioned in the first notice of default. So I feel like it's like a one and the same for me. But it says, finally and importantly, as late as August 31st, 2020, Shaw expressed Zen's pleasure with Scholt's work. Let's get to that. Okay. Thank you for the super chat, 41 Fit. These folks have some nerve, sis. Yes, they do. Hey, I said what I said. Charlene Matthews, Let's Talk Life. Thank you for saying, please hit the like button. Okay, so the August 31st, 2020, Shaw, in the email, what Shaw said was, the schedule you sent me looks good. Remember, they got the notice to proceed March of 2020. So they hadn't done a lot yet where they missed a lot yet. And Mr. Shaw was replying, if this is the schedule you're presenting and you stick to this schedule, then yes, this looks good. That's what he said in the email. But it's so, I know that's what attorneys have to do. They have to just keep playing because you never know if it could probably go in your favor or whatever. But I'm like, come on now, stop. He didn't say he was pleased, I think, with Marsau's work. I think he was pleased with the forecasting schedule, in my opinion. Okay. Thank you for becoming a Trendy Tribe member, Golden Mike. Thank you so much. We love you here. We welcome you here. Hey, Taisha J. Nisha says, so Zen didn't know one date. Meanwhile, Marsau didn't know 24 questions. Nisha, thank you. Thank you. Oh, what is this? Crafting with your flamboyant creator. Hi, I like that name. And you seem like a content creator, by the way. Okay. Let's see. Kay. Yes, thank you, Kay. Normal business practice. You have to have contingencies in place to ensure business continuity, especially for a project this size and with the amount of money involved. That's where, okay, Kay, that's where my mind went. So we're on the same page. Thank you. Okay. So then we're going to go down. It says, in short, Zen cannot provide any proof Scholt did not commence cure of default. Scholt clearly remained on the project, performing in a way that kept it on the project. That's like saying you deserve your A and all the extra credit because you sat your butt in the desk in class. You still have to do the work. You have to do the work. Let's hold on. Let me see. What do I have here? Now we're going to a legal site. Let me get that pulled up. We're going to a legal site to look at how they define a cure outside of this contract, outside of this lawsuit. And I know this may not be a be all end all, but I feel like it's at least still a pretty good idea. So we have to look at that. Context is everything. So let me see. Okay. So this is from, I think this is actually from maybe a law firm site. I'm not sure. I went and looked for things, and if I saw something that looked like it was related, we're just trying to get the gist. Okay, so it says a notice of default and opportunity to cure, considerations and limitations to examine when a contracting party fails to uphold is part of the contract. So it says the opportunity to cure is probably the most important consideration to make when faced with a contracting party whose performance has been unsatisfactory. The legal right to cure is a principle founded in contract law that allows one party in a contract who has defaulted under a contract provision to remedy their default by taking steps to ensure compliance or otherwise cure the default. The default can occur in a variety of commercial settings, from repayment of loans to performing under a construction contract. Ding, ding, that's what we're here for. And so it says, okay, we're skipping the loan repayment part. Let's see. In the construction context, owners or upstream contractors are often quick to supplement a contractor's forces or bring in a replacement contractor when they feel a contractor's work is defective, incomplete, or behind schedule. The owner or contractor will then seek to back charge its costs to correct and complete the contractor's work. Oftentimes, the relationship has deteriorated to the point where an exasperated owner or contractor will terminate or supplement immediately. However, a rash decision is almost certain to backfire because the failure to comply with applicable notice and cure provisions in a contract bars recovery on a claim based upon allegations of another non-performance. I do believe this is what Mr. what's his name, Alan Anderson. I feel like this is what Marsau's attorney may be leaning on. It says most any construction contract will include an express obligation for the non-defaulting party to provide the defaulting party with notice of the default and opportunity to cure. The principle is so ingrained in New York law that even in the absence of an express provision, a contractor has an implied right to cure its own default. This means the non-defaulting party will ultimately be found in material breach if it does not first give the contractor a reasonable opportunity to correct the defective performance. The rationale behind the right to cure is a mix of fairness and the court's collective frowning on termination of contracts in general. Most defaults in the construction context are curable and damages are available to make a party whole. What's more, only a material breach allows the non-defaulting party to supplement or terminate a contract. If a party thinks an alleged breach is serious enough to supplement the contractor's forces, or worse yet, terminate the agreement, then in fairness, the contractor should have a chance to correct the problem before the owner takes drastic action. This also encourages parties to resolve their disputes informally instead of declaring the contract terminated and rushing off to court, which in turn reduces the burden on the court systems. Okay. It says, at its most basic, a notice to cure must be specific enough to give the other party a reasonable opportunity to cure the alleged breach. It's not enough to recite conclusory allegations of non-performance by simply regurgitating language contained in the general conditions. Once the proper notice is given, the defaulting party must act to effect the cure within the time provided. Where a default is not capable of cure within the time provided, the defaulting party must begin and continue reasonable efforts to cure within the time allotted. Keep in mind, a notice to cure does not survive the other party's performance. That is, once the cure is accepted either expressly or impliedly, a new material breach requires a new notice of default and opportunity to cure. Okay. All right. I think, I think I beat the horse. So let me see. All right. It booted me out, y'all. I'm back though. Let me see. Case said Bottom Road Soul's lawyer worked for his pennies. He made something from nothing. His arguments are empty and citing cases that don't really support Scolt's position. Kay, we're on the same page. We are on the same page. Hey, my sweet LaDon. Kashori said, girl, you're the go. Kashori B, thank you. They told him and he can't show a response or an effort to make it right. So that's not going to fly, right? They gave him at least 2 notices, and I think the third was more about the audit. But yeah, he got official notice. And no responses on record from what I know of anyway. Let me get that back up here. Okay. So then it says... I cannot. I'm sorry. Let's see. To its own detriment, Zen alludes to Scholt's reference to Alabama contract interpretation law, proclaiming Alabama law requires courts to enforce contracts as written and to give their terms their ordinary and plain meanings. Scholt agrees and invites this court to examine the lack of evidence for Zen's claim for the $1 million thereunder. The $1 million was covered more in part. What am I in? Part 5? Part 4. No, we're in part 6. It was in part 5 that we covered the $1 million claim, if y'all really want to see that. Chit Chat, hey Chit Chat, also a content creator. She's a woo child is so juicy. That last statement sounded like it was favorable to the Scots, though. Chit Chat, it did, right? But we got to see their actual evidence on how they tried to cure this. But yes, that part, I was like, if you're going to tell it, you got to tell it all. I saw that. Like, I got to read everything. Hey, Beverly Childs. But yeah, Chit Chat, that is very true. She contextualized that seems like Marsau decided to use the same tactics he uses in Latisha with Zen Gardens. And everything he does. Shan said Bottom Road caused this to himself because it appears Zen was going to let him go. We do have to remember that. Zen did not bring up this case. Scholt is suing Zen, so Zen is countersuing Scholt. We do have to keep remembering that. He had to get his car painted. Tap that like button. Yes. Okay. Let's see. So now we're into Scholt says regarding fraud, Zen fails to establish reliance, which alone defeats basically apparently all of his fraud claims. So then Scholt says Zen insists the question of reliance is one for the jury. However, as Zen implicitly notes, this is only ordinarily and usually the case. Here, uncontroverted evidence shows Shaw was in no position to rely upon anything due to his admitted privity to Scholt's qualifications. In fact, Shaw was so aware of Scholt's qualifications, he made his own misrepresentations to lenders, telling the lenders he had met all the subcontractors. Let's stop there. Let me catch y'all up. So the first part says that Zen was aware of Scholt's qualifications. They were aware that he did not do a project of this size, but they were also told that he would be bringing in people like Michael Scott, which if y'all saw his resume, it is impressive. Michael Scott's resume is impressive. He was also supposed to bring in Alan Legier, and I can't remember if there's anybody else on there, but if you saw their projects on that proposal, it was impressive. So that's on Zen. They're gonna have to figure, I don't think they'll ever use a company this small again, whether they are very legitimate or not, and that sucks. But they're trying to say that they just went willingly into where it's our fault that you didn't do any of the work because you didn't have the experience. And it's like, no, you were supposed to be bringing in people with 25 to 27 years experience. So the budgeting part, figuring, and as Mr. Shaw said, he was trying to help him figure out where you can save money if you do this. Not, oh, you're not going to do the job at all because you don't know what you're doing. That's not what Zen Gardens signed up for. Okay, so then it says, let's see here. It says here, oh no, I already read that, sorry. Oh, the misrepresentation to lenders. I will not gloss over it. So what they're saying is there's an email to one of the banks that I think did not choose to give Zen Gardens the loan. The bank said that they didn't, what did they say? They said something like, with Scholt's experience, they weren't comfortable with it, basically. And Mr. Shaw from Zen Gardens said he had met all the subcontractors. In his deposition, he said he meant to say he met some or most of the contractors. So they're going to have to argue that out because I don't know how much that will impact the rest of his case. But I will be fair to say that all in the deposition, he said, I typed that, but I meant to say some, or like all the major contractors. He didn't mean every last subcontractor is what he's saying. Thank you, Charlene Matthews. What did Taisha say? I wonder if his resume was accurate. And see, I didn't see his resume, Taisha. I only saw the 2 projects he listed. See, he put more information for Uncle Mike and Alan on the proposal. He just listed his 2 projects on there. He didn't list like how Uncle Mike, we saw his education, we saw his projects. Marsau didn't put his in that proposal though. Okay, and it says, let's see, let me get back. Okay, so he told lenders he had met all the subcontractors. Mr. Shaw later said he meant all the major subcontractors, like I think electrician and things like that. Number 2, they said that Mr. Shaw said he would be personally involved in a role of construction manager, oversight, general contractor for the project. In the contract, and even I think in the emails, I believe he said he'd be there about 50% of the time. The way I was looking at it when they did their testimony or the deposition, it seemed like he was close to, if not at least at 50%, but that'll be something he'll have to prove through his travel records. And it says that Mr. Shaw said he would be traveling and spending 50% of his time minimum for the project for construction management. And it says, these actions are not characteristic of a hoodwinked individual. And in any other case, Shaw's conduct would more closely resemble that of one perpetuating a fraud. Y'all, this is where the attorney said, I'm going to really get him. He's now trying to imply, in my opinion, that Zen Gardens is the fraud. The ones that actually have the apartments and have tenants are the real frauds, y'all. That's what that's what the attorney is saying. Welcome to the Trendy Tribe, Kashori B. How are you? Thank you so much for joining us. But didn't show up on the project site. Lord have mercy. Hey, Maria Hardy. Kevin said what Scholt has done is make it impossible for the small company that has the skills and expertise to handle such a task. That's what I took. And that's what really angers me, Kevin. That is the point right there. It's like, I'm going to play semantics with you so you can't hold me accountable. And then I'm going to turn around on you. And did you defraud me? Like, that is wild. Not a hoodwink individual. Come on, Francois. You caught that hoodwinked. Okay, so let me see. So yes, they're now this bluish purple statement. They are implying that Zen Gardens is the one, or Mr. Shaw is the one perpetrating a fraud or resembling a perpetrating a fraud. And then it says Zen's bizarre efforts to establish Shaw's reliance due to mental capacity, educational background, relative sophistication, and bargaining power are equally unavailing. Setting aside what Zen appears to try to suggest about Shaw, it is clear Shaw was/is a seasoned veteran of the construction industry, highly educated in the engineering and construction realm, and held immense bargaining power. Scott's college degree, domicile in Madison County, Alabama, status as a licensed general contractor, and introduction to Eva Bank are of no consequence. So they're just like, none of it mattered. Everything's Marsau Scott said it didn't matter. That's how I'm taking it. Because Shorty said, baby, I had to join. You play no games. I'm trying, y'all. I'm trying. Claudia said when awarding a contract, there are legal stipulations you have to meet. They represented themselves as an 8A small woman-owned business that gave them a leg up on other companies. And Claudia, I believe, let's add to that, minority owned, in addition to your woman owned. And I think I'll raise you a disadvantaged zone if I'm not mistaken, Claudia. Hi, Nika. Thank you for hitting the like button. The audacity, I'm telling you. Let's see. Hey, Black women are in the building. She's a content creator as well. KNRB said, let's see whose bad karma will come to the forefront, Mr. Shaw's or bottom rows. Right. Live, laugh, love. At minimum, yes, double minority, live, laugh, love. Okay. Please like the video if you haven't had a chance to. All right. So then we're going to go to... Let me make sure I'm not repeating myself. All right. So it says, finally, Zen's due diligence argument fails. Zen's cite to Williams versus Dresser Industries Incorporated, I believe, for the position that due diligence is a jury issue is a major misstep. That case at that very site it says at that very site notes, while the question of due diligence is also generally resolved by the trier of fact, where the party complaining of fraud fails to exercise any due diligence to discover the truthfulness of representations, there is no jury question. Shaw admitted to never conducting any due diligence, foreclosing Zen's fraud claims. I would like to see if it is determined if Mr. Shaw did or did not conduct due diligence. I would like to know, because I want to know how much is his responsibility, reasonably, just normal business practices. I would like to know, so that I am curious. Let's see. Hey, Shirley Terry. Okay. Howdy stuff. The Scott's lawyer must have demanded full payment upon accepting this BS case full of fraud. I know I would. If I read this, I'd be like, oh no, you failed too. The auditors don't know what you gave them? Oh, I need all my money up front. Hey, Melanated Energy. It's not over yet. We're still getting there. We got a little bit more to go. Okay. So let's see. It's the audacity for me on some of this though. It says the last, here we go. This is where I got the word melodrama from. It says Zen's irrelevant arguments and outright melodrama cannot change the fact that Zen caused its own troubles in this matter. Wow. The last section of Zen's opposition brief accomplishes nothing. Without any support, Zen asked this court to ignore the cases Scholt cited to support Scholt's position. Zen created its own troubles. Where precedent is not particularly developed in some contexts, analogy is employed. Due to scant precedent for the present context, Scholt identified a discernible agency doctrine at work and properly applied that doctrine to the instant case. Predictably, Zen implores this court to ignore the cases cited, decrying examination of the same as baseless. Zen's alleged entitlement to remedy Scholt's continuous performance failures is also without merit. They said Zen's remedial measures were pure micromanagement consistent with Shaw's desire to be general contractor. Okay, now. They are really pulling when they said it was his desire to be general contractor. I remember that deposition. Y'all go back and watch part 1 if you want to see it. That's not how I took what that man said. And anyway, it says, in Zen's hiring spree bore a price tag Zen alone bears. They called it a hiring spree, y'all, so they could actually get done in some kind of a timely manner. It's full of laughter, hottie stuff. Furthermore, Zen's own vague citation indicates Shaw could not confirm whether he gave Scholt written notice in 2020 before hiring MNC. They are leaning hard on that. They've mentioned it again about he didn't get written notice that they hired MNC. We will see how that plays out if it goes to trial, because I would like to know. Thank you, Charlene Matthews. Say, yes, baby girl, read. Yes, ma'am. Hey, Rose. Trini, you ain't playing with this. Sorry, I'm late. I fell asleep. I've been waiting all day. Oh, Rose. I'm glad you're here. Hey, Sandra Sanderson. Okay, so the conclusion is, in summation, any recovery sought by Zen is limited to liquidated damages in a maximum amount of $323,000 as pursuant to contract. The parties agreed to waive consequential damages. Agreed liquidated damages shall be in lieu of actual damages, and further limited liquidated damages to a mere reduction of the contractor's fee of up to $323,000. I implore y'all to go back to look at the part before this one if you didn't, because we did go through the contract, and the contract does mention other ways of them getting their money outside of that contractor's fee if it met other conditions. So they're also glossing over. If somebody's glossing over, then both sides are glossing over. We shall see. But oh, Mr. Anderson. Okay. And then it says Zen cannot invoke the applicability of the $1 million clause since the contractual conditions for same were never satisfied. Zen cannot establish reliance, thus defeating its fraud claims. And Zen created its own cost overruns through its own poor business decisions, despite attempting to stick Scholt with the bill. For the reasons set forth in this brief and Scholt's initial brief, Scholt requests this court grant its motion for partial summary judgment as to Zen's counterclaims against Scholt. And let me see if I have one more clause for y'all in that contract. Let me double check myself. Hold on. I think I read it. Let me double check, but I think we read it. 12.2. Oh, no. Maybe we didn't. Let me see. Oh, I don't think we read this. Okay, final payment, because this is, they saying, Zen Gardens didn't pay them anything, right? So this is the final payment clause. It says, final payment constituting the entire unpaid balance of the contract sum shall be made by the owner to the contractor and or subcontractors as appropriate when, and here are the points. 1, the contractor has fully performed the contract except for the contractor's responsibility to correct work as provided in Article 12 of AIA Document A201-2017 and to satisfy other requirements, if any, which extend beyond final payment. Number 2, the contractor has submitted a final accounting for the cost of the work and a final application for payment. And 3, a final certificate for payment has been issued by the architect in accordance with Section 12.2.2. Number 4, owner shall have received lien waivers and indemnity agreements from contractor and any subcontractor, supplier, or laborer requested by owner, with such waivers and agreements to be in form and substance satisfactory to the owner. And 5, owner shall have received a closeout book. I told y'all that closeout book was coming back, including all warranties, a list of subcontractors and suppliers, and such other information as shall be reasonably requested by the owner. So Linda's done. Linda says Zen Gardens won the case. So we know that I think they countersued for up to the 5.5 million, right? So I want to see how much the Zen Gardens get back, because maybe, some of it they might throw out. I don't know. But I'm like, the Scholt didn't seem to not do any of the work. Like, not some. They seem like they just didn't do anything. Marsau said the building was 36. He said, what did he say, 36 inches on the show? Because in the deposition, I think he said like it was between 14 or 18. I feel like Mr. Shaw said 14. Marsau might have said 18 in the deposition. That closeout book is major, and it should be normal again, right? Because if you're in construction, the closeout book is your normal practice. You might have a team. I don't know, but somebody's job is to make sure that closeout book is being kept up until the day, because it's not like you build it when you're done. It's like I'm calling it this, but I'm not saying it's exactly like this. Like, your continuity book is built as you go. You can't build the continuity book after you're done. So I said what I said, right? I would have taken the monies. We all know they don't have it. A fixed price contract. I feel like, oh, did we see that? Because that's a good question, Veronica. I cannot recall. Let me see. Hold on. It seems like it's a cost reimbursement contract, Veronica, not fixed price, which makes more sense, especially for construction. Cost reimbursement makes more sense, I think, and it might be a cost plus reimbursement, because they did also give them, I don't know if that matters. They might have got the contractor's fee either way, but it feels like a cost reimbursement minimum, not fixed price. That's why they have to, the closeout book is based on Billy's job. Maria said they need to throw Scholt out, all of it, in the trash. Bottom row of Scholt is for the streets. Yes, that book is in the recycling and credit one recycling bin. Y'all are hilarious. Okay, she contextualizes, says it's normal practice. Are you saying CM as construction management or contract management? I'm thinking contract management though. I don't know though. I'm of the opinion Marsau is in total breach of contract. Mary Kelly, the notice of default alone, y'all, they got sent 3 of them, okay? That alone, I'm like, if they took the time out to write that and tell you how they feel you need to proceed forward, and you do not formally respond to at least, rebut it, that doesn't look good. Then you never ask for any extension to your milestone dates. That's on you as the contractor. You have to do that. Marsau told Tisha that he had to mix the concrete with his bare hands. Live Laugh Love said no, it's pay by completion and cost reimbursement. Okay, salary included in cost reimbursement. Come on, my contract ladies, let's go. Yes, thank you. Okay, construction management. Thank you. She contextualizes. It was said that the insurance will pay for the lawsuit. Oh, Sandra, they insurance could not. First of all, I don't even know if they proved they kept the insurance the whole time. Secondly, the insurance has the right to decline if it don't look right. Third, I don't know if they would cover the amount that they did because they just didn't do the work. So I don't know. I don't know about that one. Tammy said, I hope Tisha was responsible for the books. Once you got the default, that was his chance to cure. Exactly, Nisha. Exactly. Okay, y'all. We have come to the end. Look at that. Hour and 14 minutes. Oh, we did this and we got to see the things. This is good. This is good. Okay. I still got to see about what's happening tomorrow with Sketchy Saturday. I'm waiting for a couple more comments to come through in case y'all have anything else about what we've discussed so far pertaining to Scholt and Zen Gardens. Let me see. In the deposit, bottom row said he hasn't even filed in the deposition, bottom row said he hasn't even filed a claim. Thank you, Maria. Mary Kelly said they had a 30-day contract with the insurance company. You know they did, Mary. You know they did. Shan said Marsau has still never provided any proof of insurance info in all the documents. Shan, I didn't see any. Because I did try to look and I did not see a lick of insurance stuff in there. Thank you for the super chat, LS. LS, I'm going to tell you, so you have a gorgeous profile picture, by the way, but she said, great job. Thank you so much for the super chat. I want this to go to trial. She could take like, I want this to go to trial so bad. Oh my gosh. So we can cover the transcripts. I'll try my best to pull out the best parts for you. I'll be trying to skip over the fluff, but that's going to be hard because transcripts are different because people just be talking and running their mouths. They don't cut it down because they don't have to type it, Thank you, Linda. Thank you, Lil Paulette in the game. Thank you, Tay, Francois. Thank you. Thank you, Nisha. Yes, y'all. Oh, this was fun. This one was a good one. Okay. I think let me see. I think that's it. I'm just looking at my stuff for any other, announcements or anything. But if I'm back in time, we're going to have our Love and Marriage Huntsville watch along tomorrow night. And hopefully Sketchy Saturday right before the watch along, which is for everybody. I'll be live for everybody for Sketchy Saturday. Thank you, Professor Demita Joe. Skolt's business practices are shocking and upsetting. How are they running a business? Kay, I don't know. I don't know. Thank you, Talking Out Loud. Thank you for the super chat, Josie Bradley. Thank you. Said great job. Thank you. Thank you, TCB. Maria said, we're all qualified as paralegals now. Maria, I had highlighted your comment when you put that in the, in the comment section of the video. I said, that is hilarious. We are all learning things now. Loving every second of your expose. Thank you, KNRB. Y'all come back. If you care, come back. Because we're going over Destiny stuff for how she got evicted from Madani and how long everything took. We're doing that. Chit Chat said, great job trending. I wanted to go to trial just so you can cover it. Thank you. This case should go to trial. There are issues of material facts. Summary judgment should not be available because they don't agree on anything. Elisa, not one point. They don't even agree on one point, except that Marsau was from Pontiac, Michigan. I feel like that's the only thing nobody disputes, apparently. Thank you, Shan. Thank you, Dr. Minnie. Thank you, CC Star. Tyra, thank you for the super chats. Hey, Trendy Tribe, Trendsetters, and Maz, great job. Thank you, Tyra Daniels. And I don't know what happened, but Tyra, I hope you're feeling better, by the way. Thank you, Color Me Entertained. I appreciate that, Sid. Pretending Queen 3K. That scene when she said, I gotta make sure I separate that concrete from what they were doing in that one section versus the barbershop. I said, now Tisha, stop playing right now. We see how y'all do. He probably learned about where he's from. Oh my gosh, y'all are entertaining. Oh my gosh. Okay, y'all, I'm gonna let you go. We probably got some more lives we got to see each other in for tonight, so I will see y'all hopefully tomorrow. If not, I'll see you Sunday for the recap, but I'll post a notice if I'm able to go live tomorrow. You are now in the YouTube streets for your break. Oh snap, Veronica. Lord protect me. Let me say a quick prayer. This is all my personal opinion. I'm just commenting on publicly available documents. But yes, shout out. Thank you, Veronica. Okay, y'all. Bye. I'm going to play our outro song. See y'all later. Bye.
I've been taking my time. Taking all of your time, I've been taking my time, Taking all of your time, Talking about it for a while. Before we take a chance and do it, before we looking back as foolish. I've been talking about it for a while. Before we take a chance and do it, before we looking back as foolish. We got me floating, and I can take it. We got me floating, and I can't take it. We got me floating, and I can take it. We got me floating, and I can't take it. I've been taking my time, Taking all of your time, I've been taking my time, Taking all of your
All right, we going. What a money reside.